Hey friends, welcome to my channel UPSC by Levi. In this video, we are going to discuss writs, type of writs in Indian Constitution. Now let us dive straight into the topic. What is a writ? A writ is a formal written order issued by a judicial or administrative authority. Here, judicial authority means either Supreme Court or High Court, and administrative authority means an administrative body which is performing judicial function like income tax tribunal or armed forces tribunal or industrial tribunal, etc. and etc. Now, the power to issue these writs is granted to the Supreme Court and High Courts under Article 32 and Article 226 of our Constitution. Article 32. This is the article that gives the Supreme Court the authority to issue writs to enforce the fundamental rights. Dr. Ambedkar called this heart and soul of the Constitution because it allows the affected individuals to directly approach the apex court for relief. Here the term apex court means the court which is at the top, the topmost court of our country, Supreme Court, and the High Courts derive the power to issue writs from Article 226. And one more thing to remember here, the jurisdiction of High Court is greater than Supreme Court because the High Court can also issue writs for the enforcement of other rights prescribed in the Constitution, rights other than fundamental rights. Now, what are the type of writs? The Indian legal system recognizes 5 types of primary writs: Habeas Corpus, Mandamus, Prohibition, Certiorari, and Quo-Warranto. Now let me explain them one by one. Habeas Corpus. The term Habeas Corpus means to have the body of. This writ is issued by a court to a person who has detained another individual, and the court asks them to produce the detained person before the court. The court then examines the reasons and the legal effect behind such detention. If such detention is found to be unlawful or against the law, then the court will immediately order the authority to release the detained person. The writ of habeas corpus can be issued against both public authorities and individuals. Public authorities like police, etc., and private individuals like corporate office or corporations who unlawfully held some persons. However, this writ will not be issued in some cases where the detention is lawful. That means on which grounds a person is detained, they are lawful. Second one, the proceeding is for the contempt of a legislature or court, because the Constitution authorizes the Parliament or the state legislature to punish the offenders for their contempt. I will explain what is contempt of legislature or court in some other video. Now, third point, if the detention has been ordered by a competent court or the detention is outside the court's jurisdiction, that means you cannot approach the court of or the High Court of Telangana for issuing a writ for the person who got arrested in Tamil Nadu. Now, next, second writ is Mandamus. Mandamus means we command. It is a directive issued by the court to a public official asking them to perform their duty that they are legally obligated to fulfill, but either have failed or refused to perform the duty. This writ can also be issued to public bodies, corporations, or lower courts or tribunals or government agencies to ensure that they perform their official duties without fail. But mandamus cannot be issued in the following cases. First one, they cannot be issued against a private individual. And to enforce departmental instructions without statutory backing. Without statutory backing means the instructions do not have any lawful backing it means they are not required by the person to perform when the duty is discretionary rather than mandatory. Here the term discretionary means performing of such duty is optional. It is not compulsory. To enforce a contractual obligation against the President of India or the state governments. It is a very important point. The court cannot command the President of India or the state governor to do his duty. And in the same sense, the court cannot command the Chief Justice of a High Court who is acting in his own judicial capacity to perform his duty. Now, next one. Prohibition. It means to forbid. This writ is issued by a high court to a lower court or a tribunal, preventing it from acting beyond its legal authority or jurisdiction. Here, the term mandamus commands an authority to take action, while prohibition, it specifically orders an authority to refrain from continuing prohibitions that are outside its jurisdiction or either unlawful. And here, the writ of prohibition can only be issued against judicial and quasi-judicial authorities. It cannot be invoked against administrative authorities or legislative bodies like Parliament or State Assembly or private individuals or organizations. It means the Supreme Court cannot prohibit companies like Infosys or HCL to not to do something. Fourth writ, certiorari. It means to be certified or to be informed. This writ is issued by a high court to a lower court or tribunal either to transfer a case to itself or to squash the decision made by the lower authority. And when it is issued means when there is an excess of jurisdiction, that means the court has overstepped its jurisdiction, or there is lack of jurisdiction, or when there is an error in the application of law, that means the court has applied the law mistakenly. But unlike prohibition, which only prevents future actions, certiorari can be both preventive and corrective, and it can also address past legal errors. Originally, like when it was added in the Constitution, certiorari was only issued against judicial and quasi-judicial bodies. But in a 1991 ruling, the Supreme Court expanded the scope of this writ, allowing it to be issued against administrative authorities when their judgment impacts the individual's rights. And one more common thing of certiorari with prohibition is it cannot be issued against legislative bodies or private individuals and organizations. And the last writ, Quo-Warranto. And what does this mean? It means by what authority or what warrant. This writ is issued by the court to inquire the legality of a person's claim to hold a public office. Like if any person is occupying the public office, like an IAS office or an income tax office, the court can ask him by what authority are you occupying that office. It serves to prevent the unlawful occupation of a public office by someone without proper legal authority. This writ can only be issued for a public office, but not for a private office. And the public office should be established by a statutory law or the constitutional law. See, I told you, it does not apply to ministerial or private office. Here ministerial means in the state cabinet or central cabinet, the minister positions in cabinet is given to persons, and you cannot ask the government, why did you give a ministerial position, so that the court cannot issue a writ asking the prime minister or the cabinet, why did they give the certain person the ministerial position? Because it is outside their jurisdiction and the court cannot ask them. Unlike other writs, Quo-Warranto can be filed by any interested person, not just the individual directly affected by the usurpation of the office. Because remaining 4 writs they are only filed by the aggrieved person. But whereas this fifth writ, it can be filed by both aggrieved person who has got his rightful office usurped by other person, or any interested person can file this writ. Now, writ jurisdiction of Supreme Court and High Court. Supreme Court and High Court, they both have the power to issue writs, but their jurisdiction and the scope of authority differ significantly. First one, scope of rights. Under Article 32, the Supreme Court has power to issue writs is limited in enforcing fundamental rights. But in contrast, High Courts under Article 26, not only for enforcing fundamental rights, they can also issue writs for other legal purposes. It means the writ jurisdiction or the scope of rights of High Court is more than the Supreme Court. Now, territorial jurisdiction. The Supreme Court can issue against individuals or government authorities against the entire territory of India, whether it be Andaman and Nicobar or Andhra Pradesh or Arunachal Pradesh or Delhi or Kashmir. Supreme Court can issue writs against individuals belonging to any state or union territory, whereas High Courts, they have to comply with issuing writs to people only in their territorial jurisdiction. They can also issue writs outside their jurisdiction, but only if the cause of action arises within their territorial limits. Now, nature of remedy. The right to approach a Supreme Court under Article 32 is itself a fundamental right, meaning the Supreme Court cannot refuse to exercise its writs jurisdiction. Now let me tell you an important line here. The right to get the fundamental rights protected is itself a fundamental right. See how interesting this line is. The right to get your fundamental right protected is itself a fundamental right. This is what the Article 32 is all about. On the other hand, High Courts have discretionary powers. It means optional power under Article 26, allowing them to decline issuing writs in certain cases. Now, let us try and understand this question. It is asked in UPSC Prelims 2022. In this question, there are three statements given. Mandamus will not lie against a private organization unless it is entrusted with a public duty. So what does mandamus mean? It means command. When does a government command? The government can only command a public authority. It cannot command a private authority. But here, the private organization is entrusted with a public duty by the government. So then, it is possible, because as the private organization is entrusted with a public duty, then the mandamus can be issued, and the mandamus will not lie against a company even though it may be a government company. No, mandamus means we command. It means the court can command a government company to do its duty. Now, so second option is wrong. Now, third statement. Any public-minded person can be a petitioner to move to the court to obtain a writ of Quo-Warranto. I just now told you in the last writ. Quo-Warranto means by what authority? By what authority did a person occupy the public office? So, along with the aggrieved person, any interested person or public-minded person can also be a petitioner. True. So, statement 1 and statement 3 is correct. So, option C is correct. Okay guys, thank you for your attention. Now, please like, share, comment on this video, and please subscribe to my channel. And if you want me to make a video on a specific topic, please mention in the comment section. Thank you guys. Signing off.